This is my firm. My firm name is called Special Needs Lawyers. A few years ago, we just decided, why have a name of a bunch of people's names that nobody knows who they are? Why not say what we do? And thankfully, at least the Florida Bar allows us to use fictitious names as long as they reflect what we do. Arguably, we could do world's greatest law firm, but you have to kind of prove it. So we figured Special Needs Lawyers, and we had to do the lawyers, attorneys was taken. But that's who we are. And so I've been practicing law for a little over 25 years, and in the time that I've been involved in the practice, I've evolved a little bit. I started in the elder law part of it, and what I realized pretty quick was that a lot of the programs that are there for our elders, needing long-term care, nursing home care, medical care, are available for younger people with disabilities. You got Social Security programs, Medicare, even in some cases, Medicaid. And so over that time, it's kind of evolved where my average age of my client has probably gone from 80s and 90s down more. I still do a lot of that. And the three other attorneys in my firm, Charlie Robinson, who's the guy kind of in the middle there, looks a little like Santa Claus, is my mentor. He just did his 50th law school reunion. Has been practicing law for 50 years. He's one of the original founders of the Florida Bar's Elder Law section. And he's the one who taught me how to understand these programs, advocate for individuals, and he continues to do that now as an attorney in my firm. It's kind of come full circle. I worked for him 25 years ago, and he just joined my firm 2 years ago. Cole Long on the left, some of you may know him. He's on the Florida Spina Bifida Association board, statewide board. He's involved. And Linda Chamberlain, our beautiful lady in the group, is a social worker, care manager. She has a company called Aging Wisely and Easy Living. They do home health and care management. So that's kind of the approach that I bring, that I come at, because these are the people who have molded me, influenced me, and helped us develop this niche, and this niche in the special needs world is a bit of a unique one. There are not a lot of firms overall, let alone individuals around the state, who do a lot of this work. And I made a conscious decision about 5 or 6 years ago to build my practice by narrowing the focus. You know, you have one option is you start doing other things in order to increase your business, and with some great sage advice from some friends of mine and people that I know and trust, said, well, why don't you really just do what you do what you know, and focus on that. And so doing the special needs has been, I don't know if we have construction going on or if it's going to be the whole time. But the firm, again, Special Needs Lawyers, real quick, and it's the only, I don't like show of hands things, but the only thing I want to ask is, because I did a talk on Special Needs Trust last year at this program, how many of you here today actually went to that program last year? Can you just raise your hand real quick? You're the only one. That's good, because I'm not going to cover exactly, but last year it was on special needs trusts. And I spent the whole time talking about special needs trusts. I was able to go in more depth last year than I'm going to be able to go in this year, because something, I won't say brand new, but certainly new since this time last year has come into play, and those are ABLE accounts. And I've got to save a significant amount of time on those because they're new and you need to know about them. But I also want to give you the basic overview and understanding of kind of when you hear the term special needs trust, or somebody says, oh, that person's got a D4A, you're going to know what they mean. You're going to know what they mean by, they say, well, it's a third party special needs trust as opposed to a first party trust. What's the difference? Why does that matter? And you don't need to be experts in the field, but a lot of times you are, for lack of a better term, and maybe there's a better one somewhere out there, you're the bird dog in this group. You are the one that's going to say, there's something over here, you need to go get it. Or, no, we're going in the wrong way. All the answers are this way. And you may not have all the answers, but you've got to have you have to have such a broad depth of understanding and knowledge and experience. And this is a whole other area that I want you to know about it. If you want to become experts in it, I think it would be wonderful, because we need more experts in it. There are entire conferences on just special needs trusts. And we're very fortunate here in Florida that Stetson University College of Law in St. Petersburg has an elder law clinic and an elder law focus that you can do a track there. You can actually get a master's in elder law from Stetson, and they have the national, if not international, conference every year regarding special needs trusts and special needs planning. It's in St. Petersburg. It's in October. I think I've been the last 15 years, and it is the experts from around the country that come in to share their experience, their ideas, their knowledge, and what's going on. I mean, we get, the opening session is always the head of Social Security's program policy in Baltimore, Maryland, that sets the rules and writes the policy on how special needs trusts are going to apply around the country. We get them usually by a webinar, and they do their little talk and basically say, well, we really can't answer that question, and we'd like to be able to answer that one, but we really can't. But they do sometimes give us some tidbits and some nuggets, and they listen as we give them ideas. So there's a lot of attorneys that do this around the country, and they're influencing policy, and they're trying to make things better. And it's important. Special needs trust and special needs planning in particular is really important, and we're going to talk kind of about why do we even need to know about these things, and what's the point in it? So we're going to talk about special needs trusts, and then we're going to talk about ABLE accounts. ABLE are not trusts, they're accounts. It's about ABLE, and then we're going to talk about how do they work together? How can they mesh? What are the similarities? What are the differences? In the materials, I have it's a work in progress constantly. There's a chart that compares certain key issues and factors of an ABLE account versus the different kinds of special needs trusts, and does one have an advantage over the other? So, as was discussed earlier this morning, tools in your toolbox. That's what this is. It's not going to make sense for everybody, certainly not all the people that you work with, but when you have the right set of facts, the right individual in front of you, and if you can identify that this is an issue and that we need to fully explore this or it needs to go further, then at least you're adding value, and you're, in a lot of cases, making a huge impact on a person's life. And I can't think of anyone more needing of that than the people that this group serves. I mean, I work with families all the time, planning their estates, thinking about what's going to happen to them and their children when they're gone, and that's a huge issue. And I have drafted trusts that will encompass millions, tens of millions of dollars for a person with special needs. That's huge. That's going to give that person an incredible quality of life. That doesn't happen very often. We're dealing with, most of our folks have nothing. They have a Social Security check, and that's it. And maybe, as we were talking before, maybe that Social Security check has accumulated a little bit, and wow, do we have to stretch? And we have to find new ways to stretch. We have to stretch in ways money's never been stretched before for these individuals. And part of the reason that this is important is we don't, and I'm going to go into more detail on this particular topic. At the next session, we have a thing that's kind of like TED Talks, although it's not a copyright infringement. It's called GAL Talks, and we're going to talk about different things. And one of the things that I'm going to mention is that Florida, for individuals with intellectual and developmental disabilities, I just looked this up the other day. What is our per capita spending compared to a person's household income, or just income in general, in the state of Florida on individuals with intellectual and developmental disabilities? In 2015, the University of Colorado published a study that's called State of the States regarding intellectual and developmental disabilities. And what it found was that Florida's average per capita spending on individuals with intellectual and developmental disabilities is $1.99 per $1,000 of average household income. So it's basically almost 20 basis points, 0.2%. So you might say, well, is that good or is that bad? I don't know how it plays out. One way we know how it plays out is we compare it to other states. And we compare it to the national average. Nationally, it's 4.3%, and we are 1.99, or we'll give Florida the benefit of the doubt and round it to 2. It still doesn't move us up in the ranking of states, and I am I'm happy to say that Florida is not last out of 50 states plus the District of Columbia. We are not 51st. We are 50th. Only one state, and if you want to learn that state, you have to come to the next program. Only one state spends less per capita than the state of Florida, and it's probably not one you would even think about. And so we don't offer much. We don't pay for much. So we got to keep that, whatever they're going to give us, and we have to enhance it. We have to add value, add things that are not basic necessities, because Florida is not providing anything other than basics. And I think there's a real question as to whether we even do that. So special needs trusts are that unique intersection of facts where we have an individual with a disability and there's some money somewhere. That doesn't happen that often, too. Personal injury suits and things are wonderful if the other party has any money, but if they don't have anything and they hurt you, I'm sorry, you're not going to get anything from them. The individuals we serve are dependent upon us as in taxpayers in the state of Florida, to provide for these things. So we have to help them, keep these benefits, meager as they may be, and add funds. And so one of the things we were talking about is why and how does this happen? Well, I guess some of our individuals that you may work with have been injured, and they were fortunate enough that if they got injured by someone who had insurance or had some benefits on the other side, they can be compensated at least partially for it. So there's a lawsuit. Others, there's nothing. Or maybe the parents had something, or a family member left them something. Or, as we were talking about, the other thing that happens is as people are in the dependency system and they start getting a check from Social Security and it goes into the trust fund that the state holds for them, it can accumulate, and that's good. And there's a special exclusion and exemption that those dollars don't affect the individual's ability to qualify for Medicaid in Florida and certain programs. Technically, that's not a special needs trust, it's this master trust, but it in essence is a similar thing. It's a way to have money and accumulate it for when? Well, for later, when they may need it, when they have to be more independent. The problem that we see in the system is that when they age out, a lot of times it's just, here you go, here's your money. And we're doing a huge disservice. Even for people who have no disabilities or challenges, and we just give them the money. It's found money, it'll be gone real quick, and sometimes they'll be worse off afterwards than when they started because they may do some dangerous things with those dollars. But what about an individual with a disability and who will never be able to manage and handle those funds? Well, first off, we can't just turn them over to them, and even if we could, now there may be programs that they could be eligible for, like that continuing Social Security check, if it's through in a program. We're going to talk a little bit about these programs called SSI, Supplemental Security Income, that the moment they have more than $2,000 outside of some protected vehicle, like the Master Trust or an ABLE account we'll talk about, or a Special Needs Trust, they lose the check. So now that by giving them the money, they lose their income stream. And medical coverage can be a huge issue. So the idea of, and then now we're just going to focus on these special needs trusts, and then we'll talk about the others, the ABLE accounts and that. What do? They let the money still be there for the individual, keep those benefits, as meager as they may be, and then use their own dollars to give them a better quality of life. How great is that? It's a great purpose. It's a great thing. The more money, and that's what I tell my clients too, families that are planning for the kids, I'm like, the more money you can leave, the more options there are going to be, and the better your child's going to be. Because trying to replace just what you all do for these individuals, if we had to pay someone out in the private sector when they're an adult, if they still just need somebody to check in with them, and a coach, and someone to guide, and someone to talk to them, a lot of you probably do that anyway for free, and you continue, but if we had to pay someone even a modest amount of money, the money would go very quickly. So we want to have a pot of money. We want to have funds to be able to enhance. So in order to also to understand this, we have to understand the different ways that we get incomes. And I can't go into a ton of detail, though I understand one of the sessions later this afternoon, I believe, is going to be talking about some of these benefits, Social Security benefits, and there's a whole lot to learn. There's a whole other world of terminology and all these different things, but I want to talk about just three, briefly, different ways to get a check from Social Security. And the big one that most of us are probably most familiar with when you hear Social Security isn't even up here. That's just retirement benefits. But to get retirement benefits, you have to work, and you have to pay into the system. Well, the kids we're talking about certainly haven't done that yet. Now, it'd be great if they get out and they start working, and then they can put money into the system, but if they can't ever do that, or they can't do it enough to get work history and credits on their own, there's a Social Security disability insurance, which that you get from paying your taxes. You pay money into the system, and myself as an example, I've been working and I've at least got my 10 years in, so now if I get hit by that proverbial bus, and I have to be careful about that because I had a client who was hit by a bus and got a lawsuit and got a ton of money. He was just fortunate enough that if you're going to get hit by a bus, that it doesn't say city of or county of or whatever. It needs to have either a beer logo on the side or some other commercial logo, and it was a commercial logo, and they got a bunch of money. But anything can happen to any of us, and if you've been working, you can get, and that's in this guy's case, he was working. He was a manager at Starbucks, and when he got that money, he was already getting Social Security disability benefits. It's not impacted by money because he bought it. He paid for it. The problem is that a lot of our clients and the people that we work with haven't worked enough and can't get those quarters and credits. So what do they have to do? They're left to the bottom two ways of getting a check from Social Security. I'm going to skip over SSI a second and talk about the Disabled Adult Child Benefit. Or they called it a DAC benefit, and now they're kind of changing the terminology. Even still, it's a very, very slow process. They're changing it to Childhood Disability Benefits. That's a way that a son or daughter can get Social Security check on mom or dad's work history. And that's a big issue for some of our folks, because if mom or dad are deceased, that's a benefit that, first off, it goes to the child while they're a minor, whether they have a disability or not. It usually stops when they turn 18, or if they're in school, 19, but when they get out of school or turn 18, it usually stops and they say, you're on your own. You're no longer, dependent on your parents. Go do it on your own. It can continue after adulthood if they meet Social Security's definition of disability. And it can happen in one of three cases. I just mentioned mom and dad have died, or dad, either one. Or mom or dad are retired, or mom or dad are disabled themselves. So you may have some folks where the parent is disabled and the child has a disability as well. The child's benefit could continue into adulthood based on mom or dad's work history. If mom or dad are still alive and getting a check, the child's check is about half of mom or dad's check, and mom and dad get the same amount. So it's not reduced. Now, it gets to be reduced if you got 5 kids and all of them are disabled, and there's a formula. But one child with 2 parents, they get 50%. So in my example, if mom or dad are getting $1,000, the child will get $500. If mom or dad are getting $2,000, the child gets $1,000. And it's based upon how much mom or dad pay in. That program is also not based on financial need. So you don't necessarily have to have a trust to keep that particular benefit. And so it's 50% if mom or dad are still alive. If mom or dad have passed away, it jumps to 75% of their amount. So my example again, if the person, mom or dad had $1,000 and they have died, the child would get $750 a month. And it's a Social Security check, and it continues the rest of the child's lifetime as long as they remain disabled according to Social Security's rules. So that's a big program, and it can make a huge difference, and that's why sometimes it's really important to know, who are the parents? Are they still alive? Are they disabled? Are they retired? Those kinds of things. I know a lot of times you all are involved because there aren't parents in the picture, but sometimes they're there, and that's worth investigating. The worst that can happen is you say, well, there's nothing that they're eligible for whatever reason. And that's what the SSI program, Supplemental Security Income. It's a Social Security check for people who have never worked and paid enough into the system. They could still work. I have lots of people who work and still get SSI and these other programs. You just aren't making so much that it puts you over the limit, and there's formulas and there's a way to do it. And we can talk more about that, but we don't have time to go into the details of it today. Did you have a question?
Yeah, just a quick question. If a child is getting benefits as an adult child under that program, do they get Medicare as well?
Yes, but you're one slide ahead of me. That's my next slide. Thank you, though. That's a great point, because my next slide, and I'll give you a sneak peek, are the medical programs that you get based with these programs. But all right, I'll go ahead and give the answer. Yes, the answer is, if you are on Social Security disability insurance, meaning you've worked enough and paid into the system and you get a disability check on yourself, after about a 2-year waiting period, you can get Medicare, medical coverage, the same that our retirees get. The disabled adult child or childhood disability benefit after a 24-month wait also gives that red, white, and blue Medicare card, which is the same our retirees get, which is basically an 80% payer for most things, hospitalization, doctors, things like that. Can have a prescription component with it. And then we just got to cover the 20% that our retirees get the Medigap or the Medicare supplement policies for. So yes, these income streams all are tied with a medical coverage as well. So you can get medical coverage sometimes by getting these benefits. You can also get medical coverage without getting any of these benefits. I mean, for example, a lot of you probably have medical coverage right now and you don't get any of these checks right now. So how do you have medical coverage? Well, we'll talk a little bit about that too. But these are the ways to get a check. The SSI program is for people who have never either themselves paid enough in or they can't draw on anybody else's work history like a spouse or a parent. It's a welfare-based program, and that's our base program that we need to know about, because that program is the basis for all of our other Medicaid, and they call them SSI-related programs. And you'll see a chart coming up in a few slides where it's going to say SSI-related programs in Florida, and they're all most of Medicaid that you know of. Now, there's family Medicaid, which is different, but our institutional, our nursing home programs, all of our waivers, if you've heard the term Medicaid waiver, there's a Medicaid waiver program for individuals with developmental disabilities. All of those are based upon kind of spin-offs of the SSI basic program. And the rules for these special needs trusts are in the SSI policy manual, basically, that Social Security workers use. Federal rules, at least today, that could all change very, very quickly if we start block granting Medicaid dollars to the state of Florida, and depending on whether the federal government says, we're still going to set some rules and we're going to make you follow them, states, or we're just going to give you money and you guys figure it out. But right now, because the federal government sets these policies in order to get the federal dollars, and about 2/3 of our dollars in Florida, in our Medicaid program in this area, comes from the federal government, we have to follow those rules. So the world of special needs trusts and those rules are based upon these federal SSI policies. Did I answer your question, or do you want me to move on? Victor.
Yeah, Travis, just in connection to that question, could you please mention protected Medicaid?
That's a thorn in Victor and my side too. I'm gonna talk about that when I talk about the Medicaid. Thank you for reminding me. I want to make sure that I do that. So Victor's talking about Medicaid. We're talking about medical coverage. So got to remember these different income streams. So I already mentioned the top one and the bottom one have Medicare tied with them and have no financial tests. And that's kind of easy to think of, because if we remember, they don't ask Warren Buffett how much money he has in the bank on whether he can get Medicare, right? He's paid for it. At 65, if you've got enough quarters, you get Medicare. Now, you pay more for the premiums when you have a lot of income, but you still get you get Part A for free. Part B you got to pay for, and then you got your prescription plans, and it gets kind of complicated. They made it all a little more complicated when they started changing the ages for retirement. 65 is still Medicare, but you can start getting Social Security now like 62, or you can wait till you're 70, and all these things. The SSI program is tied with Medicaid in Florida. So there's different ways to get Medicaid in Florida. And Medicaid, an aid program, it's medical coverage, but it has financial tests, both income and assets in Florida. In some states, it's only income-based now with expanded Medicaid, but in Florida, it's still income and asset tests. And so here's 4, and there's probably more different ways you can get medical coverage. We talked mostly about Medicare. Medicaid, we're going to talk a little bit more about that. Those waiver programs I was referring to before, there's I forget exactly on the count, maybe about a dozen or so Medicaid waiver programs. And what the waiver indicates is that the state of Florida has been able to get the federal government to waive some type of a string or a condition of getting those federal dollars. For example, our long-term care waiver program waives a few things, but one of them is that you have to be in a nursing home to get long-term care under Florida's Medicaid program. That's the basic rule. You got to be in a nursing home to get Medicaid long-term care. Florida was able to get the federal government to allow Florida to carve out some dollars to help provide some services for people in the community, assisted living, memory care, those kinds of places. And so they waive certain requirements, and they're usually geared to a specific medical condition or diagnoses: traumatic brain injury, spinal cord injury, cystic fibrosis, HIV/AIDS, developmental disabilities, or the I budget, which doesn't make a whole lot of sense because I don't really think they've implemented the I budget yet, but the program for people with intellectual and developmental disabilities, familial dysautonomia, didn't even know what that was, and now I have like 3 clients that have this dysautonomia. That's an incredible condition. There's all these other, there's a model program, it's called. I think there's a program that has like 3 or 4 people in the state of Florida on it. That's all. I mean, how unique is that? Somebody knew somebody, didn't they, in the legislature to get a special Medicaid program just for a particular. So there's these waiver programs, and we'll talk about that. And then we have Medicaid. We have private insurance, right? I'm knocking on something because who knows what's going to happen with private insurance. The Affordable Care Act was huge for our population because of the pre-existing condition exclusions. Now, you cannot be excluded from private insurance if you have a pre-existing condition. And that's really important for our population because up until that, they were left with Medicare or Medicaid, and maybe if they could get in a group plan where there's no individual underwriting and pre-existing conditions, but for a lot of our individuals, that wasn't even an option. I'm not going to comment any more about that because when I do, I get in trouble. People usually, I offend someone one way or the other. But just keep an eye on that and know that right now it is an option. Maybe I will say this, I think we could all understand and agree that there needs to be some fine-tuning, and it's not perfect, but lots of things aren't perfect. But sometimes they're better than what we had before, and sometimes they're better than nothing. I mean, I probably did offend a few people there. But you can kind of see a little bit where my heart lies. We've got to have options, because Medicaid is not a great option. I mean, as a last resort, it is. It still is very difficult. There's been lots of great newspaper articles and studies and even court cases about Florida's lack of Medicaid provider networks, are just horrible reimbursement rates that it's very hard to get experts and to get specialists to accept individuals on Medicaid because they get nothing. It's basically a pro bono case for the surgeon if they're going to do an orthopedic procedure on a person with Medicaid. And so we've got to do better, but that gets back partly to our being 50th out of 51 potential states and districts of Columbia in the country. So now, and then back to Victor's question, we have to recognize, though, that these aren't always static programs. So you can be on SSI and get Medicaid, but what if you become ineligible for SSI? Why would that happen? We were talking before about why do people lose their SSI at 18? Well, there's a couple of reasons for that. In that, if they had no money and then all of a sudden either it's in the master trust account or something and it gets turned over to them, well, now they have too much money and it's $2,000 is the asset limit. But I mentioned most of my clients is exactly the opposite. They don't become eligible until they turn 18. Because until they're 18 and they're living at home with mom or dad or mom and dad, they count mom and dad's income and resources against them. But the moment they turn 18, even if they still live at home with mom and dad, there's no more deeming is the term. And they look at the child all by themselves and they go, this 18-year-old with severe and significant limitations, disabilities, intellectual, developmental, whatever it may be. Well, of course that person meets our definition of disability according to Social Security, and now they can become eligible for SSI because they have no money. And so they start getting a monthly check, which the maximum is $753, $35, sorry, $735 is the maximum SSI check right now, and they get Medicaid, and I have some of my clients who go, why do I even want that? I still have private insurance, and I say, well, maybe you don't need it. $700 is $700 more, then go ahead and do it and just start, saving those funds in one of these vehicles we're going to talk about for later on if they need it. You're just leaving money on the table otherwise. But I also say, go ahead and do it to my client whose grandfather was on the Forbes 50 list. I have a client with Down syndrome whose grandfather was on the Forbes 50 list not that long ago. And you know how much money you got to be on the Forbes 50 list? I don't know how much money because I'm not privy to that. I'm one of about 12 lawyers that work for this family. But when we were talking about applying for SSI for this person at age 18, they were like, what? Why would we even do that? No welfare for my child. I say, well, what about, though, if I can get them a Social Security check based upon your work history? Oh, that's nice. What if we can get a Medicare, red, white, and blue card? Well, that would be good. How can we do that? All right. You have to file for the disability, and your disability has to be a childhood one, which still, they give us a little break, which is before age 22. So I'd much rather make that argument when they're 18, 19, 20, or 21, that this person meets Social Security's definition of disability than when they're 35 or 40 and you're retiring now and you want them to get a Social Security check based on your work history. I'd much rather Social Security say, yeah, that condition was back there when they were 18. So I say file. You don't have to take the dollars. At least have Social Security make that determination so we're not making the argument later on when something happens. So we want to keep those benefits. But what if that child starts getting SSI and then mom or dad retire? Or mom or dad become disabled, or mom or dad die. Well, all of a sudden now, I'm going back and forth between these slides, but all of a sudden now, they're eligible for this disabled adult child benefit, and it's based on mom or dad's work history. Well, what if dad's Social Security check is $2,000? Well, now the child's eligible for $1,000. Well, that's more than the $735 SSI figure, so we want more money, right? More money, better. Take the CDB, the childhood disability benefits, you get now $1,000 instead of $735, and the issue is, because in Florida you get Medicaid if you get SSI, the federal government determines the SSI eligibility. The state of Florida does not. Social Security sends a letter directly to our state contracted Medicaid provider, which is AHCA, the Agency for Healthcare Administration. If you don't get Medicaid through that route, you've got to apply to the state of Florida, which is the Department of Children and Families does the financial determination for people who are applying for Medicaid in Florida. But you bypass them entirely when you get the SSI benefit because the federal government says you are Florida, a state that decided way back when you were going to take Medicaid that you were going to automatically give Medicaid to people who get SSI. So here's a person, put them on the rolls. Florida goes, Social Security says good, we're good. You got Florida Medicaid. The problem is when Social Security says, child's eligible for $1,000 on this other benefit, you're no longer eligible for SSI, they send that letter to AHCA and they go, this person's no longer on SSI, and state goes, not eligible for Medicaid anymore, boom. What they should be doing is saying, are you eligible for other Medicaid programs? And by the way, yes, there's an exact Medicaid program that Victor referred to called Protected Medicaid that says if the reason you lose your Medicaid is because you become eligible to get a Social Security check on somebody else's work history, and that amount's greater than SSI, and it caused you to lose your SSI, you keep Medicaid as long as you remain otherwise qualified. If the reason you're not qualified is only because your income is now too high, as long as you stay under the resource test of the $2,000 in countable assets, you still keep the same exact Medicaid, which is full community Medicaid, at least under the current system, no copays and deductibles and things like that. What Florida is doing incorrectly is saying, well, you're not eligible for that, you're probably going to be eligible for this other. Believe it or not, there's a worse Medicaid than that one called the share of cost or the medically needy, and they're basically putting people, and people don't know better, and they go into this share of cost, and if they've got $1,000 a month coming in, they've got to have $800 a month of medical expenses to trigger Medicaid, and it's each month. And it's wrong. They're exempted. They're grandfathered, for lack of a better term, into protected Medicaid, but you have to ask for it. You got to go right now, apply for it. Through who? not through Social Security. They're done with it. They go, you're getting more money. You don't need SSI anymore. Department of Children and Families. And so if that ever happens to you or your client, call Victor. No, don't call Victor. You can call me. You can call Victor. Call me. I have a memo that a friend of mine developed, and I adjust a little bit, that sets it all out in the law that you can then, share and get to hopefully the right people. And usually we can get it resolved. I think the thorn in the side is that you shouldn't even have to ask for it. It should happen automatically, but it happens. So when a person's losing a benefit, we need to say, is there something else that might work for them? And I've got to keep moving or I'm never going to get to the ABLE accounts. So for these SSI/now Medicaid programs that are based on SSI policy, there's a medical necessity. So yeah, there's Medicaid for children. There's Medicaid in Florida for families with minor children. There's pregnant women. There's people who are 65 or older. There's no we didn't expand Medicaid in Florida. There's no Medicaid for a healthy 30-year-old woman or man with no children, even though they're completely poor or broke. Now, I know there's some exceptions through the foster program where you can keep some medical, but just like I get people coming, I'm out of my job, I have no medical coverage. You got to have another category of eligibility still in Florida, and being disabled is one. So for these particular programs that we're only going, there's family and there's all these others, but there has to be a disability determination. So you still need to meet that test, and so there's some medical necessity. And for SSI and Medicaid, there are financial limitations. And for SSI and some of the Medicaid programs in particular, you can't have a pot of money today and say, I'm just going to put it over here. I'm going to give it to my friend to hold on to. Now I don't have any money. I'm broke. Give me Medicaid, even if you're disabled. Doesn't work that way. You can get, for SSI in particular, you'd be penalized. And for long-term care Medicaid and all those waiver programs, there's a penalty and a waiting period that if you have money today and you just give it away. And the other thing is, as a general rule, all trusts count. That's the general rule. The special needs trusts that we'll talk about are the exceptions to the rule. And it's kind of funny, a lot of people think, all these special needs trusts that we're going to kind of talk about came about in 1993 as part of an omnibus bill in Washington. The bill, though, and the idea and the whole thrust was that even then, attorneys, we could take money and we could set it aside and make these special kinds of trusts and say it doesn't count anymore. And they said, we got to stop that. We can't have people putting money in trusts and having them be exempted. So we're going to pass all these laws that say trusts all count. And then they said, but we're going to give 3 exceptions to that, and that's what we have to know what those exceptions are. So the general rule is they all count. So this is that chart that I said. It's a little bit busy. Oh, look at that. I can zoom with this thing. So they're all SSI-related programs. I'm just going to slide it over to here, kind of. So it does talk about checks that are on SSI, and then I'm not going to go into great detail because this is in the materials, but if you do any of this kind of work with any of these Medicaid programs, this chart needs to be really handy. And even for me, I still have to go back and look at, what are the limitations for these programs. The top one there, I don't think I have, that'd be cool if this had a little laser on it. No, done. But there's the 735 is the SSI figure. These other programs, and I'm going to scroll down a little bit to where they are, that have these $2,205 figures, those, oops, didn't like that, did it? These are the institutional programs down here on the left, and then this program over here, these are the waivers. And so those are the income and resource limits for the Medicaid programs, long-term care, in particular the waivers. They have a strange number of the 2205. It's not that hard, though, to keep track of because it's always 3 times the SSI the maximum benefit rate. So in the last year when it went from 733 with the cost of living increase to 735, the 2205 went up from the 2199. 2205 is a little easier to explain to people. The 2199 was kind of crazy. They go, why is it $2,199? That's the limit? Yeah, it was 3 times 733. Now it's 3 times 735. So these programs that are based upon this, what we call, again, institutional policy, have all kinds of income and asset limits. And the world that we want to deal with in the special needs trust world is, what are the exceptions? What are the exclusions? So there's 2 broad categories of trusts. There's what are called self-settled or first-party trusts, and there's third-party trusts. A lot of people say, what's the second party? I don't know. There's no real common phrase for what are second party trusts. I make it up sometimes and say it's the spouse, because there's a whole other separate set of rules if you want to set up a trust for your spouse, that it's not necessarily a first party and it kind of can be considered a third party. But self-settled, what we have to look at is whose money is it? If it's the individual's money already, why would the individual have money? Money's been saved in the master trust account, and it's going to be turned over to them when they age out. Maybe there's a family member who's left money through their will or through a beneficiary designation. Maybe that individual has been injured, and the injury was the result of someone else's negligence, and you've sued them, and now you have money. So that's their money. Third party is someone else. Third party is the best kind if we have that. That's where we have a family member who has some money and they want to set it aside for this individual who needs it a lot, but and can't manage it or handle it. So just briefly on the third-party trusts, and we're not going to focus a lot, they're set up by another family member. You can set up one of these trusts for your spouse, but you have to die. It has to be in your will. Testamentary trust. I've got a great case right now that's got legal malpractice all over it. It's great. I have a lawyer who did a trust for the spouse, embedded it under a revocable living trust for his wife that's in the nursing home, the husband did, and the husband died, and now all of her benefits are going to be terminated. And we're talking like $9,000 a month damages for the rest of her life. And it's going to be very, very difficult to save that, certainly not as well as it would have been if the lawyer would have just done a proper kind of a trust. So these have a lot of potential pitfalls. There's lots of ways to screw them up. Generally speaking, there's maybe a trust set up for one person. You can do these in a pooled type environment, and we can talk a little bit more about that. The big thing about these trusts are, though, compared to the first party trusts, is there's no Medicaid payback when they die, and that's something you're going to hear a lot. Special needs trust, is there a payback trust? Well, it makes sense, right? If the individual who has some benefits now that we want to maintain and has some money or receives some money, that we're going to let them keep the benefit and keep the money. Wow, that sounds pretty good. But we're not going to let them then hold that money for the rest. Well, first off, we can't let it, they don't give it away now. We can't say, well, you give the money away to somebody else. They say, no, you can't do that. It's your money. You got to use it for yourself. But we also don't want them to give it away when they die to their, family, friends, whoever. So there's this Medicaid lien against first-party money. But there's not when it's mom or dad or someone setting up a proper plan. There's no payback. So it can go to other family members, friends, other children when that individual passes away. The last slide on the third-party trusts are, there's lots of ways to do them. You can set them up now and fund them. You can have them funded later. You can embed these third-party trusts, as long as it's not for a spouse, within a will or within another kind of a trust. And like I mentioned before, you can actually direct these into a different kind of a pooled trust that might have a better option for you for overseeing, managing professionals if you have a small amount. If you have a lot of money, and if you have more zeros, you got all kinds of options. There's plenty of professionals, there's banks, trust companies who will be willing to do it, but if you just don't have enough zeros, and that's a hard number to know. A major institution in Florida that does really good job with special needs trusts, they have their own department, they have their own lawyer, they do an awesome job. Their minimum is $1 million cash. So, and if there's a $250,000 house plus $750,000 in cash, still doesn't meet their minimum. It's got to be cash. And that puts a lot of people out of the market. So it's a huge issue on what are the options for that. And so sometimes pooling or sometimes going to other options that we can talk about if we need to. Self-settled trusts, though, this is when it's the individual's money themselves. Quick question?
Yes, so within a testamentary trust or a will that gives the power to the PR or to the trustee to create a special needs trust, is that going to be considered self-settled or is it going to be self-settled?
It's a good question. The lawyer answer depends. But if you have language within a will or a trust that gives the discretion to the personal representative or the trustee to establish this, it could still be a third-party trust, as long as that's not the disabled individual or their spouse making that decision. Sometimes, and it's been successful, sometimes that little just throw in boilerplate provision that a lot of trusts have that just says, and if any beneficiary in here is disabled, in the trustee's discretion, then the funds will be held under this discretionary provision, can work. Now, if we know a person has a disability, we want to maybe tailor it a bit stronger and have real good language. But a third-party trust, the criteria is third-party special needs trust, the criteria is very easy to meet. The beneficiary can't revoke it or change it. They can't demand the use of the funds for their food and shelter types of expenses. That's it, pretty much. And so as long as it's in someone else's discretion other than them or their spouse, and they can't direct, they can't require it, they can't pledge against it if it has a spendthrift provision, like you can't pledge it for collateral, borrow against it, those kinds of things. That's all that it really requires. The threshold is not real high, in spite of sometimes what Social Security and other agencies think that it has to have all this special language. It's pretty specific. It doesn't. So sometimes you can accomplish it in a boilerplate type of a provision. First-party trusts, self-settled. They must be irrevocable. And again, we already talked about maybe the person has an inheritance, maybe they've earned and saved their Social Security while they're in the dependency system. This is what I want you to at least see, and again, there's days of conferences that just talk about each one of these. So we can't get all of them, but these are commonly what they're referred to. So when you hear a term, is that a D4A, or is that a D4C, a pooled trust? Those numbers come from the federal law. The 42 United States Code is the Social Security Act. And there are subsections under here, and remember these were all added in 1993. They have been amended once since then, and that amendment happened since this program last year, happened in December. So they've been only really changed of any substance one time, and so you got a D4A, which is for a person who's under the age of 65. You have something called an income trust, which is a D4B. It's not very commonly known as that. And you have a pooled trust. And we're not gonna go into great detail about each, but we'll take each of them just in a separate slide, if it will change. Yeah. So this is the one that had the change. December 13th of 2016, an individual can now establish his or her own D4A trust. Up until then, it can only be established by a parent, grandparent, legal guardian, with court approval, by the way, because a guardian has to have court approval to establish a trust, or a court by its own order or motion, which we're oftentimes able to do rather than having to do a guardianship for a person who doesn't have a parent or a grandparent. That was our fallback when, before the individual could establish their own account. I had a gentleman that came in and he was riding in a car with his best friend, and they were in a car accident, and his best friend's insurance company paid him like $60,000 or $70,000, and this guy was on SSI, and in Florida is on the Medicaid waiver program that provides him some extremely expensive medications, and he said, I gotta keep my benefit. And this is before the Special Needs Trust Fairness Act, the change that occurred, and I go, well, do you have a parent or a grandparent who's still alive? He's like, nope. And he's perfectly competent, but he's disabled. According to Social Security's definition, I said, we gotta petition the court, and we got to get the court to approve it. We don't need a guardian. So we were able to petition, and the judge said, sure, no problem, but it cost him time and money. Well, now that gentleman could sign his own trust document. He can't be the trustee, but he can establish one. So we still have the same people who can do it from before, parent, grandparent, legal guardian, court, but now the individual can do it themselves. This trust has a mandatory payback when the individual passes away. And that's about all I'm going to get into that, because we're going to move on to the others. Pooled trusts are the same basic general concept. The difference is pooled trusts are established by federal law by a nonprofit organization or corporation that can then oversee and manage it, and you have sub-accounts within it. And the idea with that is, one, it can handle smaller amounts of money, economically more efficient, and most of them have no minimum fees, so you could put $10,000 or $15,000 in there. Good luck getting a bank or a trust company to take one at $100,000, let alone 10 or 15. And these, again, are nonprofits that have to oversee it according to the Florida law. And in the interest of full disclosure, I do the Guardian Pool Trust or the Guardian Trusts, and we've been doing that for over 15 years, and we do it through a foundation, and my job is to make sure that it all runs like it's supposed to run. So it can be cost-effective and efficient. It does, though, have, I think think I have another slide. Oops, no. It does have the Medicaid lien that attaches when the individual passes away there as well. So just like with the D4As, with the D4C, you can't give the money to friends and family after the person dies unless Medicaid is paid back in its entirety. And that's an issue. And so a lot of times the trust can be completely wiped out by those liens. So they are a way to keep the money for the individual beneficiary, but not great inheritance vehicles or inheritance tools. So overview again, the basics of these: maintain benefits, keep the money, pay for things the benefits don't cover. Downsides can be, if it's in one of these self-settled trusts, it's a bit restrictive because we can't have that money being spent on other people either. It has to be only the beneficiary. They're called sole benefit. And there's a lot of rules that go along with that. And then sometimes it can be hard finding a trustee and that Medicaid lien when they pass away. So that's it right now for special needs trusts. We'll come back to that in a minute, or in probably about 10 minutes. ABLE accounts. ABLE accounts are not trusts, they are accounts. ABLE stands for Achieving a Better Life Experience. It's also called the Stephen Beck or the Stephen, I think E. Beck ABLE accounts. There's some history around it, but here's how I would explain it. And this is kind of how it started. And I'll use myself as the example. And that's fine, then I don't worry about offending anybody if I say something personal. So my wife and I were so privileged and happy to welcome a bouncing baby boy 16 years ago. He's driving now. It's kind of scary. But and so when he was born, we're like, oh boy, college, right? Got to get him through college, right? Florida prepaid, these 529 plans. So it's immediately what we did is we, and thank God, because now the prepaid college is crazy, but we did the prepaid college, so we're like, well, that's it. We get him through high school, and boom, he's booted out. And college, maybe. We'll get him through college, and we'll boot him out after that. So then about 3 years later, our daughter comes along, and we're like, ooh, college isn't the goal anymore. My daughter has Down syndrome. And so like, what do we do about this? Can't do a prepaid plan. Well, it'd be nice, maybe, but if we don't use it for school, we got problems. And that was kind of the impetus behind this. Why can we do this tax-free savings plan called a 529 for my son who's going to college, hopefully, and all that, and I can't do something similar for my daughter who maybe she's not going to go to college, but she's going to need a lot more than he's going to need. And so when it was signed by President Obama in December of 2014, it was started in Florida. The accounts were opened up July 1st, so we haven't even been available in Florida a year yet. It's called a 529A plan. So it's like a college savings plan that you can put money in. The money grows tax-free as long as you use it for proper expenses. 529 plans, it's got to be used for educational expenses. 529As can be used for lots of other things, including education, and there's a list of them in the materials. And then I gave you, as far as the materials go, I don't know if they give you the PowerPoint, but I know they give you materials. I've got my special needs trust one. I have a whole separate one about ABLE accounts, and in here, there's a detailed listing of all the things you can use the ABLE accounts for. And so here's how it works in Florida. And it's not even been a year yet, so July 1st will be a year. Most states still do not have ABLE accounts for them. In October, there were 4 states that did. I think there's more like 8 to 10 now that do. Most other states that have them will take people anywhere in the country. So Ohio, which was the first one, and I know the gentleman who helped kind of get that going, Blaine Brockman, who's very involved on a national level with a lot of this stuff. Theirs is called Stable. Ours is called ABLE United, is Florida's version. Ohio will take anybody anywhere. You can only have one account, but you can be in Florida and open an Ohio account. Florida is the only state that I'm aware of that limits it to only Florida residents. So Florida, you can do it in Florida, but you have to live in Florida in order to do it. And because it's like an educational plan, right, it makes sense, well, who's going to handle it? Who's going to handle this money if it's going to be administered by the state? And it does. It has to be administered by a state program. So Florida said, well, it's like an educational plan, right? Let's put it under our prepaid college board. And that's exactly what they did. So they established this ABLE United board under the Florida Prepaid College, and so it's administered in Tallahassee. Well, I don't know if it's in Tallahassee, but it's administered by the Florida Prepaid College Board. So I talked with them. Actually, I emailed them yesterday and today and got answers back. And so to get the current figures, but before I found that, I just found in general, so because my questions were, all right, it's been almost a year. How many people do we have? How much money's in there? What's the average size account? I have all that as of yesterday. But the Florida Prepaid College Board manages like $10 billion in assets. So they not little, and they use Vanguard and BlackRock and some of these major investment companies. We'll talk about these ABLE accounts and how they can be invested. But you can't go open one of these ABLE accounts down at the local bank. You got to do it through the program, and we'll talk about how that works. And you'd have to do it. You do it online, and it's ableunited.com. I just helped. So I started on July 1st. I forget what I was doing on the 1st. I was busy. I opened an account for my daughter on the 2nd. So I wasn't the first one, but so I've had an account for my daughter since July 2nd. And one of the questions people have is, how are the investments doing? I'll tell you exactly how the investments did as of yesterday when I checked the figures. But it took me a little while to open her account because I was using an iPad. It was a Saturday, I think, and as I was doing it, I was taking little screen captures. For those of you who do iPads, you can do little. So I was doing these screen captures because what I did is I made a slideshow, a presentation that if any of you want it, I'll email it to you. But I basically captured all of the questions that are asked for Florida's ABLE United, and I redacted any confidential. But so it took me a little while to do the first one. I opened one last week for a gentleman in my office, and it took me like 10 minutes. Quick, easy, very easy. Incidentally, the guy I opened it for is 66 years of age. So we'll talk a little bit about that on the age issue. So ABLE accounts. So we covered everything on that slide. Other just kind of tidbits, and there's one of the handouts has a question and answer thing about almost every question you could think of and the answers, and those are just straight off of ABLE United's website. You can go there. They have they spent a ton of time and money to roll that out in July. We were the third or fourth state, I think, to roll them out. And we have it's a pretty sharp and good-looking program, and there's a lot of great information on there. Some basic things, and this isn't just Florida, this is everywhere. Annual contributions to an ABLE account is limited to $14,000, which doesn't make much sense when you think about it, because I can put my own money in the ABLE account. Why should I be limited? The $14,000 is the annual gift tax exclusion. So if someone else wants to put money into an account, it's like if you want to give me money, I'll put it to good use, but you're limited to $14,000. Otherwise, we've got to start reporting things to somebody, the IRS. You're limited. It's the annual. It used to be $10,000. It's now $14,000. So basically, they said annual contributions can't exceed whatever the annual gift exclusion is, which is still $14,000 this year. It'll eventually go up to $15,000. But that's from all sources. So if mom wants to put money in, dad wants to put money in, brother wants to put money in, fine. You can't ever combine to more than the annual exclusion. So there can't be a whole lot of money in these accounts, right? I mean, because, it can't be more than 14. Well, I guess it could be more than 14,000 in Florida because it's each calendar year. So you could have put 14 in 2016, and January 1st you can put another 14. So there can't be any Florida ABLE accounts that have more than 28,000 plus their earnings, whatever that might have been. So it's limited. So that's therein is a downside. Again, we mentioned it's open at ableunited.com. It does not count. These funds do not count for those programs we were talking about, SSI, Medicaid, all the Medicaid waiver programs. And in addition to that, they wrote in, oh, and by the way, they're going to also be excluded for food assistance, for housing. Those specific exclusions are not in the Special Needs Trust law. Now, we have some special need. We have a federal case called the DeCambry case out of Massachusetts that was a housing case that seems to indicate, oh no, you can exclude certain aspects of special needs trusts for housing purposes, but as a general rule, special needs trust can be an issue. But ABLE accounts, they said, we're going to exclude them for all these things. Housing, food, Medicaid, SSI are the big ones. And the money in there grows, it's invested, and it can grow tax-free as long as it's used for certain what are called qualified disability expenses. And here's a list, and that's kind of small. It's in your materials, it's in all kinds of things, and it's easy to find these expenses. There's a whole bunch of housing expenses. There's education, of course, transportation, legal fees, all these things. Funeral and burial, basic living expenses. So some people have asked, can you pay for food? And I'm of the position that, well, the tax code, because this is a tax law, right? It's a 529 is in the Internal Revenue Code. That's actually a section of tax laws. It's not under 42 United States Code, which is the Social Security laws. So the IRS was set with having to oversee this, and they have a different kind of whole way of doing things. It says, well, we're going to say basic living expenses. And so then the question is, well, what are basic living expenses? And if you go look them up in the Internal Revenue Code, it's in U.S. Code 1, the very first section of the Internal Revenue Code that is definitions. And basic living expenses, it starts off, the very first thing is basic living expenses include the following: food. All right. So if anybody says you can't pay for food, I don't think that that's accurate. And I hear that a lot. You can't pay for food. But all these other expenses can be paid for out of an ABLE account. Oh, before I get to that, I'm going to go back. Well, I don't know if I can go back. That's that chart. I know it's kind of small. It is in the materials, a couple of different ways. Florida ABLE, just real quick, a few things about it, and then we're going to take a few minutes. We got about, by my calculations, a little less than 10 minutes, or 15 minutes left, right? I think we go till 2:15. So I'm going to do at least 5, and then I'm going to go through this chart, and then we'll open it up for some more questions. But real quick on Florida ABLE United. So what's it cost? How much money do they have? How many accounts do they have? So ABLE, it's very hard for the special needs trust to even come close to competing with ABLE accounts because of they've already got $10 billion under management, and they're just folding this little bitty thing underneath it. So how much do they have to charge? They're going to charge, not yet, they're going to charge $2.50 a month. And I say not yet because they waived the monthly fees for the first year. So starting in July, you'll pay $2.50 a month to have the account. You do pay potentially for the investments. There are 1, 2, 3, 4, it's like 7 or 8 different options for investments. If you want it to be in cash in a money market, you pay nothing for the investments. If you want it to be, in these managed portfolios that are managed by Vanguard and BlackRock, it caps out at 29 basis points. So 0.29% to have it invested. Who can do that for that kind? You get from the way that it works in Florida, and this is not every state. Some states give you like a debit card on the account. Florida doesn't do that. The way you fund the account is one of 2 ways. You go online to open the account, and it says, do you want to link this to a bank account? And that's what I did when I opened my daughter's. I just put my bank account information in, and then it says, how much do you want to move? And boom, it's gone. It's out of my account, right? It's in there. So now those accounts are linked, the ABLE account and a bank account. The one that we did with my gentleman who was 66, we linked his bank account to it. And so we just plop the money and you do electronic transfer. The other way is you can mail a check. It goes to Jacksonville, but you write it out and tells you how to write it and send it, up to $14,000 a year. So then now you got this money sitting in this ABLE account. How do you access it? Well, you can send requests to the state and you get 2 free checks a month. And then if you want more checks than that written in a month, they charge you $5 per check. Okay. Or you can do electronic transfers. You can pull money back out of the ABLE account, back into the bank account. And incidentally, it's not income when it comes back to you, so it doesn't impact these programs. And you can do that as many times as you want. So it's unlimited electronic transfers between a linked account, or you get 2 checks. There's a lot of potential problems with pulling that money back out of the account and putting out of the ABLE account and putting it into your own account. And without getting into all these details, it gets complicated because technically you can pull it out. And what I'm telling people is if you're going to do that, pull it out and spend it on one of those things that you were going to spend it on. And do it immediately or do it very quickly. There's provision that you don't have to do it immediately. So you say, well, I'm going to be moving into a new apartment and I got to put a deposit down. It's going to be $500, okay? So you could say, oh, I'm going to pull that $500 out and put it into my bank account and I'm going to put that deposit down. Oh, I didn't find an apartment this month. Or I had an apartment and it fell through, so now I'm into the next month. And that $500 puts you over the limit. Now you've got too much in your account. Technically still exempted. Don't tell people that. Tell them they got to spend it. Move it back in then until you need it. Or don't pull it until you're ready to spend it. Technically, you can pull this money down, and it can sit in the account, and you can have more than $2,000, and it continues to be excluded as long as you have this clearly identified plan to use it on a qualified disability expense. That's just confusing. Just use the money. Or just 2 checks. How many checks can you need? 2 checks a month. Let them write the checks, and then it doesn't even flow through the account. As of yesterday, there are 888 cases, accounts in Florida ABLE, with $3.1 million. It's pretty good. Nationally, I think his name was John Finch. Do you guys know him? He used to work at the ARC in Tallahassee as the director of Florida's ABLE account. Told me that that they think there's somewhere around $30 million nationally in about 5,000 accounts in ABLE accounts. But we still don't know exactly that because not everybody shares their information. In Florida, you have options for investing it, and you can allocate like 50% to one option. You have these are all portfolios, managed accounts, portfolios, conservative, moderate growth, a money market account, a bond, U.S. bond fund, U.S. stock fund, and an international stock fund. So depending on which ones of those you select, there's certain percentages. So I said, I want to see how this works. I put 50% of my daughter's account in moderate growth, in the moderate portfolio, and 50% in the growth portfolio. And there's straight stocks. So I was a little aggressive, probably more aggressive than some people would be. In 10 months, the account is up 9.3%. Hey, I should be a financial advisor. I didn't pick him. I just did but yeah, so that's pretty significant. And that money's growing tax-free as long as it, again, is being used for these qualified disability expenses. So now this chart, I can make it bigger. So this chart, what I tried to do, and then we'll go back and forth, we'll look at these, I call them traits. So how do we compare things? And I wanted it to be in a picture so that if I just showed you this and you didn't see anything more, and I say, okay, green's good, red's probably not real good, orange is maybe, maybe not. It lets you at least see how we compare these things. So in order for green to be good, my statement had to be a positive statement. It couldn't be I'm trying to think about it. It can't be high fees. Well, high fees we don't want to be green, right? High fees would have to be red, so we want low fees. So these are what I did. So I said, can the beneficiary establish the account directly? Are there limits on the contributions? Is there a Medicaid payback on death? Can it pay for food and shelter without affecting SSI? And I know I'm going through these quickly, but you have these. But can it grow tax-free? Is there a lifetime limit? And I think I skipped right over that, didn't I? There is a lifetime. So for SSI, if you have more than $100,000 in your ABLE account, the money over $1,000 starts counting toward your SSI $2,000 limit. So in theory, if you had no money anywhere else and you have $102,000 and a penny, you would be ineligible for SSI. And what that does is it terminates your SSI check. And this is really not that big of a deal right now because how long is it going to take at $14,000 a year to get to $100,000? And that's if you don't spend a penny of it. So, but if that's the case, what it does is they put your SSI in suspension, but you still keep your Medicaid in Florida and states that are tied. And the reason is you can have, for Medicaid, all by itself, in an ABLE account, whatever your state limit is for 529 plans. And in Florida, that's $418,000. So you can have up to $418,000 in a 529 educational savings plan under Florida's laws. And so from $100,000, you could start losing your SSI. Your SSI goes into suspension, and Medicaid continues until you get $418,000, and then they'll take your Medicaid away. I don't know if that's ever going to happen. And if you have a little extra in the ABLE account and then you spend it and get it back down to under the $102,000, then your SSI kicks right back in the next month. So there is a suspension if you accumulate too much, but it's going to be a long time before that's an issue. Is it exempted and protected from creditors? That's a big issue that we have. Does it allow any distributions after the person has died? That's a big issue. How do all these trusts compare? And are the fees low? Because remember, green is good. And then is there a broader standard of distributions than just sole benefit? So now we go back to these, and see if I can make this as big as we can get it. So the ABLE account's in the first line, and some of its positives are, yes, the beneficiary can establish the account on their own, but there's limits on how much can be put in. I didn't mention that, I don't think either. these ABLE accounts has a Medicaid payback when the person dies. It has a Medicaid lien, but they're allowing you to pay for a few things after the person has died, like funeral and outstanding debts. Those can be paid first before the Medicaid lien gets paid. And that's not the case in the D4A and the D4C world, the individual trusts and the pooled trusts. Third-party trusts are great because there's a whole bunch of options. They're on the far right, and they're mostly green. They don't grow tax-free. The beneficiary can't establish it themselves, but that's why it's a third party. But for the most part, the rest of it is pretty good. It's really these that we're comparing, the D4As and the ABLE accounts and the D4Cs. You can see there's certainly some limitations on the D4As and D4Cs. And then the orange ones are, the other thing is that was written right into Florida statute when we implemented the ABLE accounts in Florida is that they are exempted from creditors. Generally speaking, you can't have your money and then put it into an account or even a trust and then have it immediately, and still be the beneficiary of those dollars and have it be exempted from your creditors. It counts. You can do that in some other states, but you can't do that in Florida. So I think there's a real question whether the D4As and D4Cs are protected from creditors. I don't think they are. They just happen to be exempted accounts in determining whether you're eligible for certain programs. I will tell you that it's very rare that I've ever seen one of these accounts pierced by a creditor. They usually see it, and they see, well, it's a federal trust, it has a spendthrift provision in it, it's got an independent trustee, it's totally discretionary. I don't think I can pierce it. In fact, I haven't seen one pierced, but we've had liens on them. The IRS has liened accounts before and said, if any dollar gets distributed out of this account, it comes to us first, not to anybody else. And I think they can do that. But ABLE is specifically protected from creditors. So I say the maybe not because I really don't think a D4A and a D4C is technically protected because Florida is not, you can't do a Florida self-settled asset protection trust. I don't think it hurts to do them because you're also getting these other benefits. And like I said, I do think it's enough of a hindrance to potentially cause the creditors to just go away. They're not going to do it. The other one on the low fees, I have an orange in there because the pooled trust, I guess the benefit or the primary attraction is that you can have smaller accounts and not have large fees on them. There's no minimums as opposed to, again, if you're going to do a D4A and you're going to have a bank or a trust company, I mean, you may have to have $1 million before they're going to even be interested in it. And even if it's half that, $500,000 still puts a lot of people out of the market and out of the industry. This is a work in progress because as new ideas come up, the whole distribution standard broader than just sole benefit, that's something that was just kind of added in not that long ago because it is kind of, the way that these accounts are being administered, it says it has to be for the benefit of the individual, an ABLE account, but not necessarily the sole benefit. And there is a distinction there. And it's maybe a fine line, but I think you could argue that making distributions, that paying your rent where you live is for your benefit, but if two other people live there with you, they're benefiting if the rent's being paid 100% by an ABLE account, and I think that's okay. If you were to pay that out of a sole benefit trust, I think you got a problem because you got two other people that are benefiting from that expense being paid, and it can be a problem. So there's a lot of nuances. My goal was to give you the big picture, and I left a few minutes for questions, and you've had your hand up. I know you've been one to ask, so I'm going to get you now, and then we'll see if anybody else has any questions.
Can you link an ABLE's account to a third-party trust and have it funded on an annual basis?
It's a great question. Can you link an ABLE account to a third-party trust and have it funded on an annual basis? I think that answer is a lot clearer than can you link it to a D4A or a D4C. I think the short answer is yes, you can fund an ABLE account very clearly from a third-party trust. I think that, I won't say an easy one, but I think that's certainly easier because remember, the rules are very broad on third-party trusts. The bigger question that a lot of people have is if you have a pooled trust or a D4A and it's your money and it's in a sole benefit trust, can you put those funds into an ABLE account that now is into a for the benefit of trust? or account, not trust. So we take something for sole benefit and you're putting it into an ABLE account that might be able to benefit others. There are some real concerns and questions as to whether that's allowable or not. That question, the second one, not the third party, that second question was asked to the Social Security folks last October at the Stetson program. And their answer after they kind of, Ken Brown and Eric Skidmore kind of look at each other and they're like, we don't see any reason why you couldn't fund an ABLE account out of a D4A or a D4C. But there's nothing in the rules yet that says that. Now, also in October last year, they said that, yes, we have rewritten the Social Security policy manual regarding these special needs trusts. There are three primary sections, 1120.200, 201, and 203 in the Social Security rules that deal with all these rules regarding special needs trusts. They said we have rewritten them. We've taken a lot of input from stakeholders, and we think you're going to like the updates. They're in legal review, and we expect them to come out by the first quarter of 2017. We're past the first quarter of 2017, and it hasn't happened. So we expect, though, because the ABLE is pretty new, that it's going to be addressed in this policy. So I think the short answer is it's still a little risky to do it, but I will tell you that we have done it many times, especially with our pooled trust. Put the $14,000 per year out of a D4A or D4C trust into an ABLE account. The beneficiary who's capable and competent can control that account. They don't have to deal with another trustee, and they have a lot more independence. They have a lot more control. Granted, you're limited as to what you can put in, but in some instances, it makes good sense to use these trusts to fund up to $14,000. Independence, the last thing that I'll mention real quick, which gets a little technical, is if you pay for food or shelter expenses out of any type of special needs trust, a D4A, a D4C, or a third-party trust, and the person is on SSI, if you pay for food or 9 shelter expenses, it can reduce their SSI benefit to a certain limit. If it's paid for out of an ABLE account, it does not. So we put $1,166 a month into some people's ABLE accounts, and the reason I think that's right. I think 1166 times 12 is $14,000. So you can put $1,166 a month into an ABLE account, let that person pay $1,000 of rent and whatever, $100 in food, and there's no reduction in their SSI check. If you pay for it out of a trust, they can reduce the SSI check by a third. Huge benefit. $264, I think is the figure, per month more they get for the rest of their life. You're talking thousands of dollars of benefit. So that's how these things can work together, and I'm getting peeked in at the back door because I think we're done. We got 15 minutes of break, and then the next sessions are going to start up. Thank you so much. If you have a question, you can pop up here.